Good evening. This is Rahul Reddy live every Tuesday from 5 to 6 p.m. Central Time. Today, along with me is my business partner, Stephen Brown. Stephen, what do you have today to discuss?
Yeah, today we're going to discuss the December 2022 Visa Bulletin. Where is it? What can we expect from that? I mean, it's a little late. Whether or not you can continue the Perm Labor process when the company is going through mass layoffs. This is an issue I think is going to be big with some of these tech companies and the potential recession. Another topic is going to be the not getting paid by your H-1B employer. What are your options? And can green card holders get unemployment benefits? So, Rahul, I know you and I were checking right beforehand. December Visa Bulletin. It's not out yet. We're what, the 15th of the month, 16th of the month?
Yeah, it sometimes happens. They do go on all the way to 20th also, especially in October of 2020, Stephen, we got it all the way in September 23rd.
It was like the last week.
Yeah, last week, and even in the coming months also, it was like that. We don't know why the delays. They haven't announced anything. There are a lot of speculations in it. But we know for sure, Stephen. They said that the rest of the world, there will be a backlog.
Yeah.
What does that mean is that, especially for most of our audiences, the Indian clients have been waiting for a long period of time. There is a good chance we may not see a lot of advances in the priority date. So we may not see advances for Indian nationals.
And this was mostly for EB2, if I remember right.
Right. They definitely said about EB2. They were very silent on EB3.
Right.
But when they said that the rest of the world for EB2 will be backlogged. So what happens, Stephen, is that Indians are allowed, no country is allowed more than 7%
Right.
when the whole quota gets filled out. So what happens here is that if the rest of the world, there's a lot of demand for it, the Indian nationals will not get more than 7%, which according to them is 4,004 because we got the extra 60,000 green cards. Even though we have extra 60,000 green cards, the rest of the world demand is so high that they're expecting a backlog in EB2. If you recall, though, the previous year, which is 2022, which ended on September 30th, normally every year the rest of the world demand is about 100 to 110,000.
Right.
But in 2022, though, the demand was almost 180,000 green cards. That's a demand for the rest of the world. So if that demand goes through like that, which they told that there is a demand because they can see the number of I-140s and adjustment of status that they filed, there may be a problem. I don't know if they are delaying it because they want to calculate more thoroughly to see if they want to put a cutoff date for the rest of the world, or they want to make any adjustment of status because they need to adjudicate the 200,000 green cards that are allocated this year. So that's probably one of the reasons why they're hesitating to move what they want to do. So let's hopefully so by end of this week, I'm expecting in the Visa Bulletin. I'm not expecting a lot of forwardness in the EB2 and EB3 of India.
And we haven't seen them announce, Department of State announce who's the new Charlie, right? Like Charlie Oppenheim did the Visa Bulletin for years.
They got a temporary person to take care of it, and we don't have those kind of monthly calls that we used to have. The openness is missing, but one thing is for sure, they have used up the 280,000.
Yes, absolutely.
We have to say they did a bravo, good job last year of using the 280,000 green cards with the coordination of the State Department and the USCIS. They did a good job, though. Stephen, with the layoffs and all those things are concerned, we have put a separate video, guys. We will release it tomorrow. It's already recorded. And we want you to watch if you are affected by the layoffs or if you're anticipating to be affected by the layoffs. The reason why we want you to watch this video, which you're going to release it tomorrow, is that you need to have a dry run. Don't just get laid off and caught like naked there, okay? You need to have a dry run before to see if you're going to have a layoff, what is that you're going to do? We call in India recce. That means that if you want to murder somebody, you go and plan around and all those things. Not that you should do, but I'm just telling that it's called recce, is that they go plan around the things. What do you do? How do you escape? What do you do? So in the same fashion, though, when you are getting laid off, though, you need to have a plan of action before you get laid off. Don't get caught in this belief that you are God or goddesses and nobody can remove you from the job. And believe this, there's no job that is sacred. You can be let go at any point of time, especially in the market conditions are like this. It's better to have a layoff to see what happens If one person gets laid off, if 2% gets laid off, what are the options? We have discussed it very thoroughly. Now, this provision, what we're speaking about is what will happen to the people who are working with the companies that got laid off. It's very important for you guys to know, especially if you do not have the permanent I-140 approval. There is a chance that your company may not proceed with the labor and I-140. The reason is that for the USC, for the Labor Department, the company has to prove to the Labor Department there is no American worker available. When they are advertising and when they are proving that when they're applying for the labor certification, they're telling that Mr. Srinivas Rao has a very good skills. In that particular skill set we are looking, we couldn't find a person, US worker. Now, when they have layoffs, though, they cannot do that. The Labor Department will come to know because these are public news, and the companies may not sign the recruitment results saying that, hey, we don't have enough US workers. They may not be able to. So if you are in the H-1B and you're working for these companies that have massive layoffs, they may not be able to file a green card application, though. You may want to check it, especially Meta company, which is also called a Facebook before, was very popular before. They had some troubles. They just came out of the troubles and now they had a massive layoffs. So they may not be able to file the labor certification. Even if the labor certification has been filed, the Labor Department may deny the labor certification. The companies may not be willing to go forward with the I-140 application if your labor certification is already approved. So these are all the things that you need to take care of. We have seen that in 2008 and 9. We have seen very similar scenario in 2000 and 2001. That at that point of time, it was not a perm labor, it was a manual labor. I don't want to explain all the things because this generation is completely different, but I've seen those things in the circumstances where companies are not willing to go forward with the labor certification. So you may want to consider, let's say, for example, if you're working for a mass layoff company, though, and you don't have a labor and I-140, how long are you going to stay in this country? After 6 years, you're going to pack your bags and you want to stay in this country for a long period of time. If you want to stay in the long period of time, even though you did not get laid off, you may want to move out of this company. You may want to consider that seriously.
Yeah, and to reiterate what Rahul said, he and I put together a video that will be released tomorrow that goes more in depth on the NIV, the non-immigrant visa side, the H's, the L's, and all that. We do discuss the green card implications as well, but it really could have a lot of impact on these perm, and I think it's something that's not being recognized a lot by the immigration community. I think everybody's focused on H1s, L's, and all that, and they're not focusing on the people that are trying to get green cards.
Yes. Yeah, and anything else before we go to the topic? There are some companies, Stephen, that file the H-1Bs and they don't pay them the salaries for the employees. So if the LCA wage, let's say, is $100,000 and they don't pay, what can the employee do?
Yeah, so there's a couple of different options that you have as an employee in this situation. The first is to find a new employer. Now, if you're not getting paid and you don't have pay statements, it may be difficult to prove that you're maintaining status. I think there's some arguments if you sign an affidavit saying, hey, I'm not getting paid, and that can help with that, getting it approved, not pro-tunc, or show that you've been trying, you've been working. The other option is to complain to the Department of Labor. You as a non-immigrant are protected by the Department of Labor Wage and Hour Division. When a company signs that LCA, they're obligated, they're saying, we are going to pay this individual $100,000 or whatever the salary is. And they're obligated to pay that in normal payroll, not just $100,000 at the end of the year. It's monthly, bi-monthly, whatever it is, payroll. You can go online to the Department of Labor's website and file what's called a WH-4, which allows you to make a complaint about your lack of pay from the H-1B side. This is particularly for H-1Bs and E-3 visas because you are protected by DOL. L visa holders, TN visa holders, because there's no LCA. There's other methods with Department of Labor for not getting paid salary, but it's a little bit different.
One thing I may a little bit differ with Stephen is that the form which Stephen is referring is called WH4. I would normally, if I'm not getting paid though, I will fill the WH-4 form. Instead of sending to the labor department, I will send it to the employer though. Hey, employer, look at me. You don't give me the salary. I'm going to send this WH-4 directly to the Department of Labor. And they will act. 80% of them will definitely act. Believe me, they will act. Now, there are some 20% deadbeats that will never work, so that's different. Why I say sending it to the employer is that if you send to the Department of Labor will open an inquiry into the company. Let's say the company has 50 employees and they're not paying them 20 or 25 of those people. Then what happens is that the Department of Labor is going to go against all the employees and will check to make sure that all the people are getting paid. So if the company has less money, you're not going to get the money. You're going to only get a piece of it. But if you complain privately to the company, hey, look, I'm going to complain to the Department of Labor, first you get your money. I mean, it's very selfish of me to say that thing, but if I were you, I want to get my money first. Then I will worry about other people's money. When I'm representing a client, my client is my God. So I want the money to be given to my client first, and then I will worry about the other people.
Yeah, and the process for this is pretty simple. Department of Labor takes these accusations very seriously. Having defended clients who had no issues, but there were complaints against them, they were making all the payroll and everything. These are very detailed officers with Department of Labor, and having represented individuals who have not gotten paid, they're going to take these very seriously and ensure that you're taken care of. And to go back to what Rahul was saying, sometimes that dialogue, if you just got there, it's your first month there, maybe there was an issue with your direct deposit. Maybe they put in a number wrong. Maybe there's something that's not nefarious. But, like Rahul said, when we're talking about 25 people, you've been there 3, 4, 5 months, and you've talked to them, hey, why am I not getting paid? Maybe it's time for some real action rather than just hoping that they're going to be nice.
Anything else on that?
No.
Stephen, if I'm a green card holder, and recently a lot of people have got the green card right now, can they apply for the unemployment benefits if they are laid off?
Yeah, absolutely. So, green card holders, their spouses that have green cards, the EADs, if you're on the C9 EAD, you haven't gotten your green card yet.
Wait. If I'm a dependent AOS EAD, and if I get unemployed, I can file for the unemployment benefit?
Yes.
What if it's a main applicant?
Yeah, absolutely.
Main applicant cannot.
Yeah.
You mean to say dependent will, but the main applicant cannot.
Well, if they're on their C9 EAD.
Yeah. Well, main applicant cannot, and dependent will be able to get the benefits though. But for the H4 dependents, they will be H4 dependent also, C26. They are also eligible for the unemployment. How about the L2 dependents? Are they eligible for that?
Yeah, the L2 work authorization, the L2 spouse.
Yeah, L2 spouse, not the L1.
Not the L1.
Okay. So L1s cannot, H1s cannot, the main applicant in the adjustment of status cannot because their 485 may be denied, but the dependents of the 485s can, and H4 EADs, green card holders, and green card holders, spouses who are also green card holders are all eligible for the unemployment benefits. So people ask me the question, what if, will there be any trouble for the public charge? No. Is unemployment benefit a public charge?
No. You actually pay into it, right? Your employer pays into the unemployment kitty, if you will, to make sure you're protected.
Okay. Anything else before we go to questions?
No, let's go to...
A question that comes from Vijay Raghavan is that if the H1B gets laid off, can they move into B2? Yes, that's fine. You can. You can move into B2 if your intention is only to temporarily stay in the United States and pack your bags and go. It could be a good option. We want you to watch the video which we released it. We are going to release it tomorrow.
Sachin asked a question on Facebook. Are people working directly with end clients on their payroll also getting 221Gs these days? Can a trip to India be easily planned or should it be avoided? Seeing a huge uptick, Rahul, in 221Gs. I have some theories behind it. I think, Department of State's a little bit undermanned maybe, but they're taking those checks and, having those appointments. We've seen 221Gs issued for people that are working at Fortune 500 companies. I filed a lawsuit today for someone who's working at a company directly that's a very well-known company. It's still getting a 221Gs. 221Gs are high right now. I'm not going to tell you don't travel. I think you just need to be cautious, and potentially you're going to see a delay on your travel back in.
Question from Jay. He has filed the I-140 application September 2021, and it's been misplaced. What? No receipt notice, no check deduction. That's not good, Jay. It should have been realized way before, within the 6 months expiration of your labor certification. It would have been easily corrected. Right now, the only option is to file the I-140 again, prove it to the USCIS that, look, here is a FedEx that was delivered at that point of time, and have an affidavit by the lawyer and the legal assistant saying that they put the envelope, it was there, it was delivered to the USCIS, and what happened, they can't know. And based on that, the USCIS may allow you to file the 485 application.
Searcher just asked a question. Can I work for 2 weeks and also work for a new H-1B employer after the new company files the transfer? No. Unless your company filed for concurrent employment, you can only work for one H-1B employer at a time. Now, conversely, if you get your H-1B approved with Company B and you say, hey, Company B, I need 2 weeks to wrap up everything with Company A, and you only work for Company A during that 2 weeks, that is okay, but you cannot work for both unless you have concurrent employment.
My priority date is December 12, 2014. EB3, can I expect my green card in the next 3 years? Mamta, assuming that if everything goes normally, though, I mean, what the USCIS and the Department of State is telling is that the demand for the rest of the world is very high. So if the demand for the rest of the world is very high, and there are 35,000 green cards that are pending for the EB3 application, since your priority date is December 12, 2014, you are definitely in the bottom of all the things that are there right now. So expecting it within 3 years seems to be very unlikely. I want you to dig in deep and guys, EAD is not that bad of a deal, guys. You can enjoy the EAD. If you think that, oh, I'm going to get the green card next month, I'm going to get the green card next month, you'll be very disappointed, especially when the priority date is not current. If I were you, Mamta, I just want to sip a nice coconut and relax and think that, okay, the EAD is going to take a long time for me to get it. One thing is that you got rid of all the end client letter, vendor letter, and so on and so forth to file, and filing fees and all those things you let go. Right now, EAD is so easy to get it approved. And I have never seen any EAD getting denied. So you can file the EAD application and get the EAD, and it's valid for 2 years. And luckily, if you file an extension before the EAD expires, you have up to 540 days to work on that EAD, even if it's not approved. So you have all these benefits. If I were you, I will just have a nice coconut and enjoy it. And Mamta, don't forget that. Do keep writing the letters. We put a link out there to stop counting the family members. So unless some miracle happens, which may happen in this lame duck session, or if there is any administrative change, though, it may take a long time. Or who knows? There may be other COVID. God forbid, it should never happen. But if something will happen, it may get current for you.
Ravi asks, are there any chances of EB1C getting exhausted anytime soon, again in fiscal year 2023? So, Ravi, what happened in fiscal year 2022 is actually, in a way, a positive thing. I know it may not have been good for you, and I'm not happy with the way USCIS met it, but they adjudicated all available visas. I take some issue with the way they jumped around a little bit, but there's not been any indication that we've seen any or can expect any retrogression in the EB1 category, and there hasn't been in quite some time, as long as I remember looking at the Visa Bulletin. So I don't think we're going to see any retrogression. If they get to the end of the fiscal year and they've used all the allocated visas, that's different. It would roll over to fiscal year 2024. But I don't see EB1 retrogressing anytime soon. Knock on wood, though.
My prior date is November 2014. I filed for EB2 and EB3. Can I extend both EADs? Yeah, you can. Well, it's free. You can. You paid for it, the $1,225 that you filed for the 485 application. You're eligible for it.
Sachin asks, so with layoffs, it's not necessary that every visa holder will be laid off. What about people that aren't laid off? Even for them, the company might hesitate. Sachin, I assume you mean the perm. Yeah, when there's layoffs, it can really interrupt the perm process and potentially the green card process. Whether it's additional recruiting efforts that they have to do or a lot of different boxes and audits that they're going to have to go through to sponsor that position. One thing they're going to have to do when there's a layoff is reach out to the laid off U.S. workers that are in that field. And they're going to have to attest there's not available U.S. workers. And when you've just laid off a bunch of people in that department, that's going to be hard to do. So even if you aren't laid off, you may have an impact on your perm process.
Kumar Ali from Facebook has this question. The letter that you're speaking about, shall I send it every month? No, I would not recommend. There are different people, though, that you can send it to, which were listed there. One is USCIS director, ombudsman, the congressman, and senator. These are the 4 people we suggest you to send. But don't send it every month. No, absolutely. What I would recommend to you, though, is have your friends send it to, have your family send it. Go to these Indian organizations where you sit down in their thing and put a table there. Hey, everybody who comes in, please, here is a computer, I give it to you, and you please send this letter in front of me. That's the better way to deal with it. Or in the family gatherings that you get to, I normally put it there. Please send it out, these things. So if you keep sending those things by different people to the different agencies or different persons that we listed there, would be much better. No, do not send it every month. It's not going to be any good.
Casey on YouTube, B2 visa stayed for 10 months. At the 5-month mark, applied for an I-539, got fingerprinting done. Status still shows after 1.5 years that it's pending. Any issues with travel? So I'm assuming when you say 10 months, is 10 months total, you 6 months did the extension at the 5-month mark. And if that's the case, the answer is no issues. These I-539s can take a long time to adjudicate. It's not something that's a problem. And if the B2 visa holder left and is now coming back in, they shouldn't face much of an issue if that's the case.
Question that comes out is whether if if I get my EAD, if I later get married, can that person get the EAD? Chirag, what it depends is if the priority date is still current. So let's say if the priority date was current for you in August of 2022, you filed, you got an EAD. Now you got married. If the priority date is not current, though, you cannot add her to the employment-based immigration. Though. The priority date has to be current again to add her into the application. Otherwise, you will not be able
to. Let me see. I had one that I was just about to. Anbu from YouTube. My H-1B visa is valid until 2024, but I use AP to re-enter the U.S. So any problems with my H-1B? It gets a little weird. I think is the right way to say this. So here's the thing that I always tell people. One, when you enter it on AP, you have your EAD and AP, right? You have the combo card or the AP separate, you have your EAD. You can always work pursuant to that EAD for your H-1B employer. There is guidance that allows you to extend H-1Bs even if you entered on AP. And I've talked with plenty of attorneys in our office, other offices that have not had issues with doing that. If you want to take a super conservative approach, one approach would be to travel to Mexico, come back in with your H-1B, even with the expired visa stamp, and you'll clear it up, you're on H-1B. I think that's an extremely conservative approach, but one that's worth looking into.
VSK from YouTube has this question. Does layoff affect the I-140 application process even if one approved in a previous company? No, VSK, you are good. You absolutely will not have any problem. You will be fine. I just want you guys a little bit advice as a lawyer that has been, too old to be there, still survived 2 recessions and looking into the 3rd one. One thing that when you speak with the previous people who have had the situations in 2008 and 2009, most probably you won't hear anybody from 2001 and 2000 and 2001 because most probably they already got the green card. But there's been a lot of difference of enforcement changes. In 2008 and 9, we didn't see a lot of exodus going from US to India. At that point of time, they may not have been checking the pay stubs that closely. I have not seen them enforcing the 90-day unemployment and the OPT. The STEM extension did not exist at that point of time. There were different rules. The way the enforcement of the rules were quite different. Now, if you don't have an employment on the OPT or STEM extension, you definitely have to leave the country. One thing I will tell you is that in the OPT period, though, you do not have to have a paying job. Even a training without getting paid is allowed in the OPT. In the STEM extension, you have to get paid. Now, does it have to be a full-time job? No, it can be a little bit reduced hours too. You can consider those options without leaving the country though.
Question from YouTube. Using the 60-day grace period when an H-1B holder changes from H-1 to B-2 and continues to stay here, once the candidate gets the job, how can they get back to H-1B? Do you have to leave the country or not? Raul and I kind of discussed this strategy in depth on our video that we're going to post tomorrow, but I'll talk about it here. One strategy that I tend to recommend to our clients is that you can apply for the change of status from B2 pending or B2 status to H1. And if the B2 is still pending, you apply for it. You can't work on H1B until it's approved. And ask them to approve the B visa and then immediately approve the H1B. And we've seen that work. Your worst case scenario here is that they can approve the H1B but deny the change of status, and you've got to go for consular processing at that point. So it's worth taking that risk because there's no extra fees. You're not doing anything unlawful. You're just trying to get the change of status approved by asking them, approve the B visa, immediately put me back into H. And if it works, great. If it doesn't, you're in the same situation you were had you done consular process.
GP Krishna Mohan has this question. His priority date is November 2015. How can he convert his I-140 into EAD? Right now, there's nothing you can do. The only thing is that write the letter that we have given to you. That's all you can do. And keep watching our videos. If there is any changes, we will let you know. This question comes from not original name from YouTube. His son is diagnosed with autistic disorder. The civil surgeon has marked Class B condition in 693. Will that cause a denial or delay of adjudicating the green card? I'm assuming that you're making more than $60,000 a year, which most of the audiences, especially your IT guy. It should not cause any problem in either delay or denying your adjudication of the green card. You will be fine. If there is anything, if the guy looks into it, he will be very sympathetic to you.
Praveen asks, what about this high demand for EB2 rest of the world? Like, where's that coming from? And if we could elaborate on the reasoning. So USCIS and Department of State no longer really publish the inventory that they used to publish. What we saw all of a sudden was that November Visa Bulletin paragraph comes out that says, hey, rest of the world might have to retrogress just to temper demand in EB2. And I don't know if this is just an increase in more people having degrees, if it's NIWs that are increasing for rest of the world. Unfortunately, Praveen, we don't get this inventory like we did years ago of what's approved, what's not.
Yeah, previously we used to have an inventory that what is the priority date of each month, which countries they belong to. Rest of the world, China and India were segregated, and they've been given separate chats though. Since Trump administration come in, they stopped it. I don't know why Biden administration is not starting it yet. As Stephen has pointed out, we just got the notification, public notification, but not the inventory of how many. We don't even know how many EB1s are there. We don't even know how many rest of the world applications are pending. We only know EB2 inventory for Indian nationals and EB3 inventory for Indian nationals. And we don't even know out of those things how many are duplicate either.
And we only got that because of a declaration in a court case. It wasn't like they publicly posted this somewhere. Ravi asks, it's my favorite question for you, Rahul. What's your green card predictions for 2023?
I don't have good predictions for 2023, especially for Indian nationals, unless there is some change in the administration. The main reason is that the rest of the world demand is very high. And if I will not be surprised if the dates won't move beyond June of 2012. I mean, that's
Well, I think the short period we're seeing on the filing date is kind of indicative of that too.
yeah. And why the predictions have changed is one, they wasted the 60,000 green cards in 2021 quota, and also the rest of the world is what is surprising to me. I've been practicing immigration law from, I don't know, generations now. And all of a sudden, I see a lot of jump high in the rest of the world, which was never there. I've been practicing immigration law before the per country quota was a little bit different, Stephen. Back when I started practicing immigration law, there was a strict per country quota limit. That means that no country can get more than 7%. So what they used to do between 2000, when I started practicing, that's somewhere 2005, I remember that from that time. From 2005 to 2001 or 2002 was that if, let's say, only 60,000 rest of the world is there, they used to give 10,000 to Indian nationals because of the 7% approximately. So that's 70,000. They used to waste the rest of the 70,000 green cards every year. So the US, the Congress at that point of time thought that why are we wasting these green cards when there is no demand? We will give it to the countries that are using more. That's when the priority dates became current from then onwards, all the way to about 2004 or 2005. Then they started backlogging. Right. Because the Indians' demand went up, the rest of the world demand went a little bit higher. But even continuously after 2007, 2008, the rest of the world demand was lower. Surprisingly, in the past 2 years actually, the rest of the world demand went up very significantly. And because of that, the Indian nationals are getting very less number of green cards, percentage-wise. Right. Because of the extra numbers that we got, we Indians got more green card last year. But going forward, though, for EB2, it's going to be 2,800 green cards for the entire Indian nationals. And that includes the family members. And when I went to Irving, Irving and Frisco, though, I mean, those 2,200 will be in the Richwood community in Frisco.
Yeah, I mean, unfortunately, I think that's one thing, and I know Raul's talking about our letter. I mean, they're counting family members to this. And so when you figure everybody's at least married, at least, maybe one kid or not, now it's really half the number of green cards that are available for Indian nationals. A question from YouTube, could there be an overlap of 1 to 2 weeks on my H-1B when I change from employer A to employer B? So you can't work for both companies, but if you get company B's approved and you say, hey, company B, I need 2 weeks to close out with company A, that's fine, but you can't work with both of them at the same time.
Khushbu Desai asks, does doctrine of dual intent apply for GCEAD or AVR if needed for H-1B before extension? It's a very confusing question. One thing, there is no dual intent. H-1B is a dual intent. You don't have a problem with H-1B and GCEAD. You can travel on H-1B also while you have GCEAD and AP. Absolutely not a problem. You can also do the automatic revalidation while you are GCEAD and H-1B. Absolutely not a problem.
A question from Sachin. Is there premium processing for H4 and will there be one sometime? This is a question I get quite a bit. There is not right now. So with all the COVID stuff and USCIS was talking about funding issues, Congress went ahead and allowed them to expand premium processing. And they were very slow to develop regulations on this. And I think it was last September, I feel like, that we finally saw what these regulations were, or they were due last September. We finally saw them in the spring, something like that. We saw the regulations come out, and they were going to slowly implement premium processing expansions. Of course, they're quick to bump up the fee to $2,500, but they're slow to expand premium. So we're starting to see it on EB1s and getting expanded. In the regulation that came out, they anticipate expanding it to H4 for fiscal year 2025. Now, hopefully it's going to be sooner than that, but that's what they anticipated in the regulation. So it's a long way out. They're staff training, hiring, all that stuff.
Stephen, as an alternative to premium processing, I would recommend these people to travel to Mexico and
Yeah.
actually get the extension done instead of spending these $2,500 to the USCIS. Have a nice margarita and have extra tequila in there and free. And you can travel and have a nice, all paid, all inclusive resorts in Cancun and come back and get the 540-day extension though. If you don't know what that I'm speaking about, it's called 540 days. Just search in the YouTube 540 days H4 extension, Reddy and Neumann. You will find out that that video. It's very good. Instead of waiting for the premium processing, you may want to do this option if you're eligible for. Most of the people whose I-94 is not expired are eligible for it. I mean, you already have H1B premium processing. Once the H1B is approved, you take the H4 extension receipt notice and go outside the country and come back, and they will extend not outside the country, only to Mexico. That's the reason I said tequila and margarita. Please, those are famous in Mexico. You go there, have them come back, and you extend it. You have the 540 days. I mean, it's a nice vacation. Lesser than $2,500, you can go all inclusive, eat, drink what you want, and come back.
A question from Shiva. Any problem in filing concurrent H-1B? No. Other than there's not a lot of guidance from USCIS, so there's a lot of gray areas in the concurrent employment that there's not strict guidance on. It's a very, it's there, use it, it's designed, use it the way it's designed.
Dr. D. Shankar Reddy from YouTube has this question. Perm is approved now. Will the company file an I-140 and 485? It depends on the company. I mean, if you're speaking about the company that has layoffs, though, it depends on the company. If the company doesn't have a layoff, they shouldn't have any problem in filing it. But if the company has a layoff, it is up to them to do it. And some of the companies that we noticed in 2008 and 2009, they did not file the I-140. It's very dangerous, though. Now, when the recession happens, though, there is also other things that will come into play. There's a lot of public relations games that come in, especially in 2008 and 2009. There was another thing that came out called government assistance to the companies. And when they took the assistance from the companies, so they said that no more H-1B extensions for those companies, Stephen, for some of the companies. And green card and other things also have become a lot of problem, though. So you may experience all these things. That's the reason we tell you to have a dry run, have a recce, how you're going to prepare for it, what happened there. Please watch our video that we put it tomorrow.
Question from Deepak. Some news about providing visa extensions from the U.S. Any updates on that? No updates. So this came about. So prior to 9/11, Department of State did do visa extensions, the actual visa in your passport in the United States. You send it to the Department of State. They send it back to you just like you do your renewal of your passport. They stopped doing that. They said they didn't have the biometrics and some of the technology infrastructure to be able to do it. At the AILA conference this summer, they said, "Hey, we're looking at doing this again." And I sat in on a talk with the Department of State a couple months ago, and they said, "Yep, we want to do this again." They're talking that they still need to go through Congress, which I don't know why they need Congress. There's some funding issues and stuff like that. So we've not seen any progress on it, but it's something that they seem to indicate that they want to do.
Ganeshan has this question. What is this 204I? Do you know anything about it?
Yeah, I looked it up. It's a relief for surviving family member.
Okay. This is when the main applicant passes away, there will be dependents. For example, if you have an I-140 approval, and let's say if I have an I-140 approval, I die, my wife and my child should get the benefits as if though the I-140 belongs to my wife. Yes, there are some relief that is available there, especially from the main applicant's dies.
A question from Ravi. Can you shed some details on EB1 international managers? So EB1C, very similar to L1. In fact, we've seen an increase of people getting L1s, leaving the U.S. on their H1, getting L1As, coming back so they could get their EB1. The big thing is you've got to work for a company that has a international branch, affiliate, subsidiary, whichever it is. There's a lot of details on the qualifying relationship between the two entities, and you have to manage professionals for at least 1 year overseas And then, that's going to be the job in the United States, is managing professionals. And that's the big thing. It's not just managing, lower level people. You've got to be managing professionals.
Question, can I change my employer before 180 days pending for 485? I do have an EAD and AP. I would recommend not to. I mean, definitely you will be risking yourself out there. The rule says that the job offer from the previous company should exist for 180 days after they file the 485. You can make the argument that the job offer still existed even though you moved to company B. There are a lot of arguments that can be made, Shah. Because look, we are lawyers. We will make arguments for you. As long as you have the money, we will make arguments. But some of the arguments we win, some of the arguments we don't. Irrespective, we get paid. So if you want to avoid that, paying the money and not getting the reward, sometimes maybe you'll get the reward, is if you can avoid it, stay there until 180 days. Now, if you cannot stay there for 180 days, then of course you move on to the EAD and AP. And then you contact a lawyer to see what are the defenses available for you. But if you can stay there for 180 days, no matter what lawyer says to you, you don't feed the lawyer unnecessarily.
Primas, how do you switch from H1 to EAD when you're already laid off? First off, I want to say that this is going to depend on the type of EAD. If you're talking about your green card EAD, because you're got a pending AOS, just go around, find your next employer, hand them that green card EAD. You're good to go. That's an unfettered right to work. If you're talking about H4 EAD, this is where the 60-day grace period comes in. You have 60 days from the date of cessation of employment. I know that sounds like a super weird term, but that's the way the term is written in the regulation. When you're terminated, when you're laid off, you have 60 days from that date as long as your I-94 is still valid. During that time, you can find a new H-1B employer or change your non-immigrant status to another non-immigrant visa, such as H-4. And if you qualify for H-4 and your spouse has an approved I-140, you can apply for your EAD as well. They're getting a little bit better on the processing times. They're not great. They're not where I think they should be, but they're getting a little bit better at that.
I don't know why people hesitate using the EAD though. Why did they want to do the H-1B? It's very intriguing to me. Believe me guys, when I was on adjustment of status EAD, I have used it. I became an immigration lawyer. I used it. Now, I can't tell you guys to continue using the H-1B when I myself have used it. I was a dependent adjustment of status EAD. I've used it. I have no hesitation. Going back, if I were put in the same circumstances, I would use the EAD because employment in EAD is so easy. I mean, as Stephen has pointed out, just take the EAD and give it to them.
That's all you got to do.
No filing fees, no LCA, no posting, no end client letter, no vendor letter, no signing the document, no paying the fees to the immigration. Sometimes the fees is $6,000 to the immigration, and then plus you pay to the lawyers. Really? You want to do all that? I don't know what.
Yeah, the interim benefits, the C9 EAD and the AP are designed to be quasi green card benefits. It was recognized that, look, sometimes green cards take a long time. There's a lot to go through. And so it was designed to give people in the U.S. who are trying to adjust status kind of the benefits of having a green card, that unfettered right to work and the ability to travel without having to go to the consulate. So
why does the entire world says them to maintain the H-1B statement?
I don't know. It's, look, the only reason you should be maintaining the H-1B is if you think your I-140 is going to get denied, or if you're looking to change for preference categories, if you're trying to downgrade, upgrade. But even then, I think there's some workarounds.
With regards to, especially with the I-140 is not approved, I personally still do not recommend. But when you want to switch to EB3 to EB2, you don't need to be an H-1B to switch to EB3, EB2. Even if you move from company A to company B can still file an EB2 application, still move. You don't have to be an H-1B.
What happens if the AP is not approved right at the time we start using the EAD, so you've got to travel on emergency without an H-1B?
Oh, this question comes out so much.
I know. So we started seeing this over the summer where they started segregating the EAD and AP. They say, people are more concerned about their work. When we were just talking about everybody using their non-immigrant visas, I think the AP is a little bit more of a need. Rahul, I mean, if I don't have an H-1B, it's expired, and I travel, I abandon the 485, don't I?
No, if you don't have an advance parole,
Right.
no H-1B.
Yeah.
Now, there are certain things that you can lose the benefits, though. That's something that you can still file a H-1B and go for the stamping and come back.
Yeah.
Okay? And God knows when your H-1B stamping appointment is there. Assuming that you extend the H-1B, okay? You extend the H-1B. You don't have the stamping. You can't come back into the country, even though you have an H-1B. And there are no visa slots that are easily available. So for that little bit sacrifice, though, you get the whole world and you get to get rid of us.
Another interesting question on this topic is the EAD attached to a specific category, EB2, EB3. I got it part of a downgrade EB2 to EB3. No. As long as you have a pending 485 and, with one of those preference categories, go ahead, use your interim benefits.
Yeah. I mean, you got to sacrifice a little bit to get rid of the immigration lawyers, but you need to. I mean, that particular 1 month or 2 months travel, though, I mean, right now, the advance parole extensions are taking maybe 7 months instead of 6 months. Yeah, there may be a 1 month delay in your travel. Yes, there may be emergencies, you have to sacrifice that. But that emergencies will still be there. That emergencies will still cause a problem for you, even if you're on H-1B, because there's no stamping available. Every time you go outside the country, you have to get the stamping before you come back. Who knows, next time they may not stamp you. They may issue a 221G and put you out there.
Yeah, I actually had a call with a client of mine last week, and I asked them, I said, guys, I'm not in the CAC system. When are you guys seeing appointments? This is September of 2023. I mean, that's a year away to get appointments, and then God forbid you get a 221G.
Is it fine to change the employer with approved I-140 waiting for the dates to become current, EB2 November 2015? Probably. If I were you, I would. Now, Mr. Krishnamohan, I might have said completely different stories before, though. When I thought that the priority dates would move forward, I definitely thought it was. But right now, things have changed. They have clearly said that no EB2's Indians are going to only get 4,004. And they said there's already an inventory of 40,000 green cards whose priority date is before January 1st of 2015.
Sandeep asked a question. B2, he's on B2 to H1 is filed, and the extension for the B2s, B2 to H1 is filed as an extension to the consular process with the B2 still pending. What are the outcomes? His attorney is insisting on consular process. The attorney is not wrong. When you're going from your B2 pending, you're not in status, therefore you can't change status. The argument that our office has come up with is that there's no risk in applying for the change of status and asking them to adjudicate the B visa and then immediately put you in H1. You're not paying extra fees. You're not working until the H1B gets approved regardless. There's no risk. Maybe you get an RFE on it, but they can, H1Bs are two-prong approvals. Do you qualify for the benefit? Do you get that green sheet of paper at all? And then do you qualify for the change or extension of status? And they can approve the H-1B but deny the change of status. That's right. Why I'm in this situation, I tend to recommend to take the risk and do the change of status, because your worst case scenario is they can approve the H-1B, assuming it's otherwise approvable, and deny the change of status, and now you're consular processing anyway.
Question that comes from Deepak is can you provide some news with regards to the visa extension within USA? Yes, they are considering. The Department of State is considering. However, they are unable to figure it out because they don't have a place where to stamp the visas. How do they stamp the visa stamping? They have more than 200 consulates around the world, though. Why can't they ask one of the consulate, hey, consulate, what do you do? Well, we do this one. Well, send one mission to me. A couple of missions to us. But they are working on it right now.
I got a brand new passport for all three of my kids within 4 weeks sitting at the Department of State, and they're telling me they can't do visa stamping.
Yeah. But they're doing it 200 locations outside the country.
I know.
they'll be more tamper-proof when they are in United States. So I don't know. I don't know where they get these people.
Optimistic investor. So am I forced to stay in the U.S. until I get my AP? The company lawyers so that I can still travel, but will have to refile. There are risks associated with the AP. So if your AP, your initial AP is not approved and you travel, that will be abandoned. You'd have to refile. That's not a big deal. We deal with that all the time. You don't pay any fees or anything with the AP. No big deal. If you don't have an H or an L visa, status and you travel, there could be abandonment issues with the 485 that you'd have to apply for. But if you're on H or L and you travel and come back in even without AP, you should be fine.
Ganeshan has this question. If I move to company B in India, and if my priority date becomes current, can I pursue my GC? Only your company can do it. If you move to India, the one thing that I would want you to do is that convert your green card into consular processing. Because once the priority date becomes current, and if you want to then move it though, it's going to take 2 extra years. So if you have contemplating to going to India at any point of time, convert into consular processing. And people may ask question, what if I decide to stay back in the United States? It won't harm you. Even though you told the USCIS and State Department that you're going to get the visa stamping in India, and now you change, no, I'll stay here, it won't waste any of your time. You can directly file the 485 application. What wastes your time is that if you don't tell the consular processing, when the priority date becomes current, you file on I-824, it takes a heck a lot of time to get that application to the consulate.
Camille has a question. I'm curious to see what you're seeing on this. Can the NBC, the National Benefit Center, approve a 485 direct letters and go to the field office? I feel like in Q4, when they're trying to approve everything, we saw some coming out of NBC.
Actually, it's the other way around, Steven. I saw more in the Q3 and Q2. Starting in Q4 or so, that is starting in July or August, they started moving everything to the district office.
Gotcha.
So nowadays, we are not seeing any approvals from NBC. In Q4, we saw some.
Right.
Not that.
Yeah, but it was earlier, sorry.
Yeah, in the early part of the Q4, we saw. But later part of it, we never saw anything. Right now, they're moving everything to the district office.
Hey, kid, I saw one. While H1 to H4 change of status is pending and H1B transfer is filed, which gets approved for consular processing, can I go back or can I go out, come back in using the existing valid H1B stamp or need a new stamp? Absolutely. You could take that approved I-797 for consular processing, take the valid visa, go out, come back in. There's no problem with that. We did a video on this a few months back about changes in jobs with visas and all that, and you can do that.
I have approved EB3 EAD AP, but I filed 485J in June 2012 in the EAD now for EB2. Can I move to a different company? What will be the consequences? If you move within 6 months after you file the 485J to convert into EB2 though, if you move out of the company, there is a chance that you may get stuck with EB3. Okay, EB3, there is a chance. I would say that there is about 20% chance that you may be stuck with EB3 because you moved within 6 months after you file the 485J supplement.
Question, is it actually possible to get back the wasted green cards? Or is it just a rumor? My opinion is that I think to get back the wasted green cards, it would take congressional action. Rahul, if I remember right, they tried that with the omnibus budget bill last year and it got shut down.
I may disagree with you. I think so they can. The administration can do it.
I know they tried it with Congress.
Of course, they are doing a lot of things, not counting the family members also. Congress tried to do it, and there are a lot of things. But the administration, I think so, can do it. They can reuse the green cards that they have given 1 million people, DACA people, EAD applications. They can allow the people who have an I-140 approval to file the EAD application. They cannot count the family members. They can use the unused green cards that have been wasted, 250,000 plus though, that were wasted from between 1992 and 2005. Yes, they can do a lot of those things.
And I think the big thing to take away from this is contact your congressman, your congressperson, your senators, about all these ideas and how to make things better. Interestingly, I think it goes both from employment-based immigration. It really crosses both sides of the aisle. It's not just Democrats who typically be in favor of immigration. Republicans are really big on high-skilled immigration. So reach out to your congressperson, your senators on these, and they can either have these brought up during congressional inquiries or whatever.
A question from Rajesh. I entered United States on advance parole. Does it make my wife's H-4 visa invalid? She does not have an advance parole. No, she is fine. Even though you entered an advance parole, if your H-1B is still valid, you are still an H-1B. Even though your I-94 says advance parole, it's still valid. Even though if your I-94 is expired, because advance parole, they normally give only for 1 year, if your H-1B is still valid, you are still an H-1B. You can still extend the H-1B. You can still change the company on H-1B.
Question from SS here. My H-1 is expiring. Haven't received an EAD yet. What are my options? So I assume in this scenario, your 485's pending. You should be able to extend your H-1B even if your final action date is current for at least the 1 year, potentially 3 if your final action date is not current. Is there a delay in USCIS sending receipts for H-1 transfer even in premium processing? I haven't seen it. That's not to say that it isn't. It's just not. I don't track the timing of receipts until I start seeing a trend in issues. I'm not seeing the premium processing emails be delayed like we saw for a little bit earlier this year, towards the end of June. But potentially the receipts are a little bit delayed. I just haven't tracked it. That's not to say anything's wrong. I just don't know how to answer that best.
The optimistic investor, he doesn't have an advance parole. His lawyers are telling that he can travel and then he can come back and then he can refile the advance parole. As long as you have a non-immigrant visa, which you're getting stamped or you're already stamped, no, absolutely refiling is never a problem. It won't cause any problem for your EAD. It will not cause any problem for your adjustment of status.
Krishna asks, can I-140 approve priority date even though it's revoked within 6 months by the employer when filed by a new employer? Your I-140 priority date sticks to you the moment your I-140 is approved. The day your I-140 is approved, that priority date is yours. Now, you can't get all the other benefits of having an approved I-140 if it's not after 6 months, but that priority date can still be ported over.
Anything else, Stephen?
No, I think we've hit most of them. The 60-day grace period thing is something Raul and I had talked this morning. We wanted to really hit on in a video. We're seeing all sorts of articles about mass tech layoffs, potential recession, and now seeing articles about how it's impacting. Of course, we knew the 60-day grace period was a thing, but we wanted to get you guys that information. That video will be up tomorrow. I read an article today as well that's on our website. Stay tuned to our social media on it.
One thing I want to answer, Gagan Dillon, and this is a lot of people are considering it very seriously, especially if the priority date is backlog. But I want people to understand, he's asking, is it worth pursuing the EB-5 option? It's up to you though, whether you want to pursue the EB-5 or not. But I want you to understand the ground realities of EB-5. You get the people say that, okay, you file the EB-5 application, you get an EAD within 3 months. It may be true, you're right. It may be true that you may get an EAD within 3 months after you file an EB-5, especially now the USCIS has allowed the I-529 to file along with the 485 application. But what people don't tell, the people who take all your big amount of $1 million, what they don't tell you is how long it's taking for an EB-5 green card to obtain. Don't listen to me. Go to the USCIS website, processing time, and look into the I-529. That's the application you're going to file it for filing the 485 application. The processing time, which they say, which most of the time they lie, USCIS, they don't give the processing time properly, is 46 months. So once that I-529 is approved, then your 485 will be approved. So approximately around 50 months it takes for you to get the green card. Now, here's a question, Stephen. Is it a real green card?
That's just the conditional one.
What do you mean conditional? I paid you $1 million and I paid you so much money.
Yeah, so you're only going to get a temporary green card, I think, what, 3 years?
2 years.
2 years.
Yeah.
For the conditional green card, and then you're going to have to apply to remove the conditions to get the full green card.
So 50 months for you to get the green card, and then you wait for 2 months, which is 24 months. You can file within like 3 months, 90 days before the green card expires. So that's approximately 70 months. Then you file called I-8, I forgot, 1, 2, I'm not good in numbers. And once you file the I-812, then what happens is that they take 16 months for you to get the green card. That's a permanent green card. So
I-829.
I-829. First is you get to 46 months plus 24 months. That's about 70 months, right? Yeah, that's about 70 months. Plus you wait for plus 60 months. That's 130 months. That's 11 years. Well, it's 2 months short of 11 years. That's the time it gets. Now, if the business doesn't do good, there are a lot of buts and ifs in the investments. Now, that's a different issue that you need to evaluate. With all that money, I don't know. But as long as, if you have a couple of $1 million and you want to put $1 million and try it as a side though, that probably is worth. But if that's the only money that you have, that's a lot of money, which with very less assurances of getting the green card finally. When I advise people, I believe that okay, they lose the money, but as long as they get the green card, I'm fine with it. But they lose the money and they don't get the green cards, and we in Hindi call it as na ghar ka na ghat ka. So be careful on these EB-5s. And they do advertise a lot to get your money.
I think I remember a conference Rahul and I went to that. Get your green card in 3 months. All these shirts going around.
And these teenage kids were advertising that. Anything else?
No, thank you.
Thank you very much.